colleagues, I give floor to Mykhailo Zhernakov, candidate of legal law sciences, Dmytro Yakymchuk, coordinator of monitoring company of Transparency International Ukraine. When will Ukrainian courts start filing court cases against the corrupt officials? This is the topic of this briefing. My name is Fedir Oryschiuk. I represent the Transparency International joint project with the first instance. So I named judges in the crosshair. So we united under the task of control over the judicial system work. On daily basis there are thousands of different bylaws, documents, sentences, etc. And of course we could not cover all of them. We selected a niche for ourselves in monitoring of anti-corruption sentences of Ukrainian law courts. So the situation is not very enthusiastic because we analyzed 100 sentences based on Article 386 of Criminal Code, which is the sentences for bribes in plain language. This analysis gave us very interesting opinion. It is very good to take bribes in Ukraine. If you have this chance, just take bribe. Because out of 100 sentences that were nominated in the last 3 months, only 21 people were jailed, means 21 court decision was approved. 19 sentences resulted in jail sentence, but it was replaced immediately by probation period. For 70 sentences, the convicted were cleaned, and 48 and 48 sentences, they resulted in fines. So what are we speaking of? On one hand, our legislation provides for very wide range of punishment. For 60,000 hryvnia bribe, you may pay fine of 25 hryvnia or have a sentence of 4 years. 20,000 to 60,000, 3 to 6 years in jail, etc. We understand that the courts, they incline toward milder sentences. Somebody will ask us, who are you that you replace courts instead of in order to understand what type of sentence should be make. So we may act as journalists and compare different crimes and different sentences. So in one case, a person has a sentence, a term in jail. In the similar case, somebody could just pay fine. As an example, 1,000 hryvnia bribe, the deputy chief physician of Bar Hospital was punished by 25,000. Tax official, tax inspectorate from Chernihiv took bribe of 60,000 and was fined at 25,000. So this, everything, all that, documents, all that materials could be seen at the website of the court of first instance, or first appearance. So the question is, why the bribes are, why it is profitable for you to take bribes. So we tried to calculate the correlation between the average amount of bribe and the punishment. So the people accused in bribes that were acquitted, on average they had 112,000 hryvnia. People who served probation period, they had 75,000. People who were jailed, 40,000 hryvnia had as a bribe. It means the higher the bribe is, the bigger you have a chance that you will be acquitted. So this is very simple result of our analysis of the 100 sentences. The same approach could be applied to fines that are appointed by court decisions. The approach is very strange to punishment in that case. The average amount in 48 cases out of 100, the corrupted officials were punished. The average bribe is 16,000 hryvnia. The average punishment is 20,000 hryvnia. So nothing happens, because if you take 16,000 bribe, then you will be fined at the same amount, roughly. In order to illustrate the sentences for corruption crimes, you remember Vasil Volga case that last year was excused for good behavior, and his bribe amount was 500,000. So we found this court decision in the register of court decisions. The formulations are great in this document. The court even took into account such arguments as, for instance, this person was against the traditional behavior of criminals. And it is very interesting as well to learn how many people was paroled we found a great amount of doubtful decisions. One of that is the case of Vita Почтova, head of village council, who took a bribe of 40,000 hryvnia, and he was acquitted. Not to dwell deeper into details of this decision, the reason for this acquittance was that the bribe was considered as a sponsorship assistance to his village. We have a lot of similar examples. You may find all of them here. We found top 10 of them in our mind. We selected the most illustrative. Probably the picture is not that full, but it is illustrative, nevertheless. We have a similar case with Petr Melnik. You remember that he was excused for 100,000 hryvnia bribe, and prosecutor's office started investigation for that type of accusation, for the bribes, and now his arrest, home arrest, they tried to continue to extinguish it, but he still is under investigation, but he is not limited to his home, so he is out of that condition. And similar cases you may find in the register of the court decisions. For instance, this is the case of Belaevka District Court. The amount of bribe was 280,000 hryvnia with the use of intermediary, and finally she was cleaned, she was excused, but that intermediary, he was accused for a felony, for say a small felony, and that's why
these decisions that courts are taking at the moment attract the attention of the journalists, the attention of the society, and that's clear why. If there are any journalists here, I would like to ask you to use actively the register of court decision, because we take our information from that register, and thanks to that single register of court decisions, we took that 100 cases we analyzed that I presented now. And that is a big and good source of information, not just to look for some doubtful decisions, but also when you're looking for some scandalous information you might be interested in. There are no such registers except for Russia and Ukraine. In the world there are not so many registers like this one, so we shall use this great possibility. That is the main part I would like to tell you. And now I would like to give the floor to my colleague, to the expert of Transparency International, Dmytro Yakymchuk, who will tell us how to control the judges using other tools. Thank you. Thank you, Fedir. Good afternoon. My name is Dmytro Yakymchuk. And we in Transparency International Ukraine taking great experience of work with declaration, and we are on the second year already of working with declaration. We monitor the money status of the officials, their family, their style of life. Is it true or not? Together with the project, and the first stage is monitoring of the judges. We started that widespread analysis from Kyiv judges. All Kyiv judges got requests for their declarations or informations from them, and everybody except for Shevchenko court replied us. Shevchenkivsky court didn't tell us anything, and we send us second request. What can we find in the declaration? First of all, we can find their status. And also we can see the expenses of the family members of the judges. From our experience, when we analyzed more than 400 up to 500 declarations of the officials for 2014, but after analyzing the declarations of Kyiv's judges, we can see the new trend. First of all, not all family members agree to publish their main status. And Dniprovsky court of Kyiv didn't publish information at all about the family members of the judge. That's why we couldn't see what they own, But that is the breach, because all the information from declaration, except for personal details, shall be published. But Dniprovsky court in their website didn't publish this information at all, only the information about the judges themselves. Except for that, there are many interesting information we found in the declaration. I won't tell you everything, because we are planning the same as previous campaign, declaration without decoration, to publish them on weekly or on monthly basis, where we can find doubtful or strange moment from the declaration. But I would like to tell you now the fact that we almost haven't seen before. For almost 500 declarations, we could see it only 4 or 5 times, but in the declaration of judges, we can see it almost in every case. This is article gifts, prizes of the family members of the judges. So, Appellation Administrative Court, where 58 judges are working, the family members of 9 of them didn't approve using the data from their declaration. And among them, there are 4 judges and their family members had gifts, prizes, and just you can see the amounts of these prizes. The family members of the Judge Goryanov got prizes for 800,000 grivna. Family members of Natalia Litvin got 1,590,000 grivna. Family members of Troyan Natalia got 1,060,000 grivna. Family members of Alexander Kreml got 678 grivna. Abolonsky District Court. Family members of Lyshuk Taras got 548,000 grivna. Podilsky District Court of Kyiv. Family members of 3 judges didn't approve to publish the publication of their data. Family members of Borodai Vasil got presents for 67,000. Golosievsky Court. Family members of Vladichenko got prizes for 100,000 grivna. And Pechersky District Court of Kyiv. Family members of Belotserskivsky Oleg got 1,468 grivna. So this is a trend. We didn't even proceed all the declaration, but we can see that family members are so lucky in the lotteries and win often, or maybe they have some rich friends that give them such an expensive gifts. I think that's very interesting in any case, and requires our additional attention.
Besides, where shall we take declarations of judges? If we consider the judges' declaration, not necessarily all the judges like to open their data. That's why we have a law on purification of power. According to that law, we have a special schedule for civil servants and judges, including have to be audited or checked with the open data appeared on websites. So first of all, you may send requests to the courts. Secondly, you may use website of judicial power. This is the name of this site, and they have a chapter of purification of power or cleaning of power. All the activists, citizens, you may use this chapter in our infographics with all the addresses, web addresses depicted, and please use the Uniform State Register of Court Judgments. You may check data in the open registers, like Open Register of Property Ownership, and the so-called Persha Instantia website with all the facts, analysis and interesting news. As you may see, unfortunately our judicial system has a lot of drawbacks. Again, the system is fortified greatly, and we should have reforms and changes in order to be corrected. Our colleague Mykhailo will tell you about that. Good afternoon, everybody. Thank you, dear colleagues, for this very interesting study. So, to clarify, I am a judge, but I was dismissed, and I work for a reform package organization. And when you ask when the courts start filing the cases of corruption, as I may say never, because the judicial system is unable, existing judicial system is unable to fight corruption, because according to our data, the system is corruption itself. Because nearly 100% Ukrainians, they understand that the judicial system is corrupted and they do not trust it. The level of trust to judicial system is 5%, including partly trusted and not trustworthy, but probably. And the level of trust to judicial power in Ukraine is the lowest in Europe and one of the lowest in the world. Ukrainians understand that the problem number one of judicial power is corruption. Problem number two is dependence from the political currents and oligarchs. We may see very interesting figures, ambiguous figures, and some of them are very absurd, because for bribes of 50,000 hryvnia, they are fined, convicted are fined by 25,000 hryvnia, or for instance when courts try to make a judgment, the amount of parole is smaller than the amount of bribe. So everything is clear in this system for us. The question is, what steps should be made in order that the system works properly? Once again, I support my colleagues and say that the information today is one of the most powerful resources. We collect this information that is related to judicial system, and in any case this information will be used in order to make such persons pay for their crimes. Unfortunately today not a single law is working. Out of 3 of them, they were adopted in order to clean power. So the latest law, that is the right to have fair justice, but this law doesn't work. Why? Because the representatives of judicial power, they put obstacles to this process. And again, another problem is constitutional process. Constitutional Commission is working over changes to constitutional system, judicial system of Ukraine, and the grounds for corruption. I should not say that this is the major cause of changes to Ukrainian constitution. Could be. And there are a lot of reasons for improper judicial system is acting provisions, acting lines of Ukrainian constitutions. The Constitutional Commission is working on that, but unfortunately not very fruitfully, because in the mind of Reanimation reform package and other experts do not consider that this is instrumental for the constitutional reform, but it is rather conservation, preserving the existing situation. So nothing is, no provisions there are for removal of presidential influence on the judges' selection, and no reforms in judicial systems. Not a single judge was dismissed according to the procedure that is stipulated by the 3 laws mentioned that were adopted in order to clean the judicial power. That's why today we insist on the process of transparent competition for all positions of judges in judicial systems, which is in line with the Article 4 of the judicial reform that was adopted by Parliament, and the future coalition should understand, members of that coalition should understand that it must be started from zero, from scratch. It could be similar to the new police. We are trying to create new judicial system, and according to European standards, the courts and judges must be arranged based on the law. All the courts must have judges that are appointed by means of transparent procedure. The majority, vast majority of judges acting today, working today, never went through any competition. They just were appointed in their vast majority. They are corrupted. In order to provide for a judicial system that would be able to punish corruptionists, and this is not the only one function of judicial system, but it is very important function of judicial system. We must not have any tolerance to corruption, and unfortunately in Ukraine the judicial system could not provide for that. In order to have this introduced, we must have an entire judicial system reformation with a transparent procedure for selection of judges, and of course judges are very important component of this system, because judge must have a discretion, means must be able to decide what type of punishment to be made. And only the judges with a new way of new mentality could be members of these systems. Now we have Q&A session. Thank you very much. And dear colleagues, if you have any questions or comments, please start to ask questions. Evgen Vorobyov. I represent the consulting mission of European Union in Ukraine. I have 2 questions. First one to Fedir. Fedir, you listed a lot of officials that became convicted in the corruption cases. Could you please tell us about the position of such people? Probably it's heads of state administration, district or regional administration. The same for prosecutor's office and law enforcement. How many of them work for law enforcement agencies? 100 sentences we analyzed. They are placed to the site of Transparency International, to the site of the Persha Instantia. You will have everybody there: tax inspectors, militia inspectors, heads of state administrations, and even head of state financial or fiscal service in Zaporizhia. In this top 10 I could see them. As well, we have here even acting rector of Lviv Financial Academy, heads of Ministry of Defense, some judges. The range is rather wide, and I couldn't give you any statistics for law enforcers, but it will be very easy for you to understand if you transpose that website into Excel format. You will have all the statistics there. Next question, please. Konstantin Simonenko, Skeptic Internet Media. I would like to ask all the speakers the average amount of bribe in Ukraine before we had this information from the Ministry of Interior. Could you please give us average figure of contemporary bribe? And since we have corruption, anti-corruption activity, at least in words, bribers, do they incorporate the risks into the bribes they take, if this amount of average bribe has risen?
I can tell you the following figures. That 100 cases we analyzed and that were made based on the article of Criminal Code 368. Total it's 5.86 billion hryvnia. So if we divide it by 100, you will get the figure you need, the size of the average bribe. But maybe it won't be exactly the figure you want to get, as we are talking about just about 100 last cases. I don't know how good it coincides with the annual figure. I also can repeat that the average amount of bribe, according to the decisions, the decisions of fee was 16,000 hryvnia, and that was the bribe, and average amount of the fee is 20.4 thousand hryvnia. About funds, you were asking funds that judges are getting, or I can't evaluate it. I just can repeat that according to the data we got based on the analysis of these 100 cases, average size of the bribe was 112,000, and these people who were put into jail 40,000 hryvnia. But you can interpret it any way you like. Thank you. I would like to add, in the context of risk, why I was talking about it in the context of judges, that it's very important to collect this information, as that selection we have at the moment, and we'll have it sooner or later, not depending on the decision of Constitutional Committee. This text is prepared already, but it allows to have it. It will foresee the check of the reputation of the judge, maybe not in the context of state officials, as there is information about them that they got bribe, but that's about judges who gave unfair decisions, and judges with the questions to their declarations. That clearance of powers foresees the competition between two or more candidates, where we can check the reputation. If judge has a track of corruption investigations, of course it will be against this candidate. Why can't we bring to responsibility the judges now? Because now we need to prove for sure that this benefit was given, or that the decision was unfair, and only that our courts shall create the punishment for such cases. But according to the system, the more the benefit, the less is the punishment. I can explain it only by the absence of logic in the system, that we can't bring to responsibility judges or other officials. The more information we analyze now, the more information we can use in the future. Thank you. Thank you, Mykhailo. Mykhailo, we have few more questions. Larissa Desiatko. Vinnytska region, election committee number 11 in Vinnytsia. On regular basis, for few elections, we have the same head. We have the same specialists in the committee, and they are selecting whoever they want as a head, as a secretary. They influence the parties, and so on and so forth. There is a kind of corruption component. As the members of regional election committee is a part of this process, and how we can influence that? I'm sorry, we are not expert in this direction. Who can I ask? I can't answer you, sorry. It depends on if you think that can be some crime or something. Maybe you can ask police or prosecutor's office. But in any case, if everything is in legal frame, but there are the same people, maybe there is a sign we need to change legislation for elections. Next question. Newspaper Юридичный вестник Украины. My question is about that article, this article of the Criminal Code of Ukraine about unfair decisions of the judges. Do we need this article at all? Because some reputable people, like a member of the committee Oryschiuk, told that we need to eliminate it. And the question to you as lawyer, some time ago, the Council of the Judges was furious that bringing the judges to responsibility using this article happens at the moment when their decisions are not cancelled. Is it possible to bring the judge to responsibility for unfair decision if this decision wasn't cancelled yet? Thank you very much in advance. Thank you. Really, it's a complicated issue. I will start from the end. I want to point your attention that, first of all, the Council of Judges is furious all the time, last time, and for unfair decisions and for the evaluation, usually it doesn't agree the evaluation committee for this for the judicial system cleaning. But about the Article 375 you are asking, I'm deeply sure that this article is contradictory, as if we had proof that other authorities have good reputation, I mean prosecutor's office or other authorities that are investigating these crimes, we would be sure that they will do it in a good way and will bring responsibility to the judges who made unfair decisions. But, on my opinion, it contradicts the standards of independent judicial system, because we can't bring to responsibility the judge for we can bring the judge to the things that was the base of his decision, but the content of the decision is a sensitive issue. But about the decisions that were not cancelled, I can give you examples of the decisions on activists of Maidan, when there were decisions of the measures, and after that they were not cancelled. Activists were fired by the Act of Parliament, as far as you remember. And actually, these decisions of the court were not cancelled later, but it doesn't mean, as these judges come and they say, our decisions were not cancelled, so what, automatically? They're fair? I don't think so. And one more. We are not sure that appellation court or other courts are reputable. We
may speak about that, and I strongly believe that it should not be the major point here, because this is patently illegal or legal decision, it was already made. Thank you, colleagues. Let us make my press briefing over, and our next press conference